All right. Hello, everyone. My name is Nate Neuberger. I'm in our business law group here at Reinhart. I think we have a lot of people following along at home to supplement our robust in-house audience here. So we've already had cracks about putting up spit guard and breath mints, so I think we're well on our way to a successful presentation. So Reinhart in our business law group, we're a middle market corporate law firm. We do a lot of middle market M&A. I personally do a lot of middle market private equity transactions. I've been at Reinhart about 3.5 years. Before I was at Reinhart, I was at a firm in Chicago for about 5 years. There I did a lot of multinational M&A and capital markets transactions. So throughout my career, I've always dealt a lot with transactions that involve Delaware law. It's really been central to a lot of the corporate transactions that I work on. It's very common for transactional practitioners to have Delaware law be central in the deals that they work on. So I've always tried to sort of keep up on what's going on in Delaware, see what cases are coming out of Delaware, what the legislature's up to, those sorts of things. It's helpful from I guess a professional perspective to stay on top of things. And then also, the cases that come out are all sort of a cautionary tale. A lot of the transactions you work on at least go hopefully relatively smoothly. Sometimes things go sideways and there's issues to work out, but most transactions don't end up in court. So the ones that do end up in court, there's some lessons to be learned. So reading the cases that come out of Delaware, it's pretty interesting to see where these transactions go awry and what folks should think about in the future to sort of avoid ending up in that circumstance next time around. So why do we care about Delaware? Delaware's been essential in corporate law for a very long time, but from a state, there's not a lot to really. It's sort of an unremarkable small state. Does anybody here know anything about Delaware at all? Come on now. Other than Joe Biden. Exactly. State beverage for Delaware is milk, if that tells you anything about Delaware. The state marine animal is a horseshoe crab. So there's not really a lot going on in Delaware. It's just a state that people don't really think a whole lot about. Now, from a corporate law perspective, though, we do really care about Delaware quite a bit. So why? Well, first of all, Delaware's got the Delaware General Corporation Law and other statutes. The Delaware legislature has really made an effort over decades now to really try to attract corporations and corporate law and try to have those folks come to their state and use their state as a place to set up shop and do business from a corporate law perspective. So they spent a lot of time developing these statutes, the corporation law and other legal entity statutes that are efficient. They're designed to work well. They put a lot of thought into it and a lot of resources into making these statutes function well that a lot of states don't do. They have case law going back decades. If you ever researched a corporate law issue, more than likely it was citing a lot of Delaware cases. Even if you look at a corporate law issue under other state law, a lot of times they just end up citing to Delaware law because there's just not cases in other states that interpret a sort of a sophisticated business transaction. They tend to end up in Delaware law and maybe New York law for some other things, but Delaware law is certainly up there. Delaware's got the Chancery Court. Chancery Court's designed to be a sort of expert, specialized court to hear business transactions. The judges there are intended to be sort of the preeminent judges that understand sophisticated business transactions, and they really they see these cases day in and day out, and they do really develop that expertise and understand the ins and outs of these types of cases. And then Delaware has more legal entities resident than natural persons. So it's something like 900,000 people live in Delaware. There's over 1 million legal entities formed in Delaware. So to administer all those fake people, you need to have a pretty sophisticated administrative background. And so they've got the Division of Corporations, and it's very easy to do business there, to do filings, to get filings out of there, to do corporate changes. They make it very easy for you if you want to go to Delaware and set up shop there as your home state. It's a bit of a state tax play that Delaware has. There's no state-level corporate income tax in Delaware, but what Delaware doesn't have is a state income tax on intangibles, intangibles royalties. So what this encourages is that companies that are headquartered in other states, they can form a Delaware subsidiary and park some of their IP in that Delaware subsidiary and pay a royalty to that Delaware subsidiary, and some of that royalty can come out tax-free. It's a bit of a loophole in other states where the main business operations are that get irritated, needless to say. So they've been really trying to close this loophole in the past, and I think there's fewer and fewer states where this actually works, but it's out there, and I think it was one of the reasons why so many people were encouraged to incorporate at least some of their business entities in Delaware in the first place. And does anybody know who this guy is? It is Movember, but I don't think he's a participant. His name is Viktor Brushev or something like that. He is a Belarusian arms smuggler. And so for years, a couple decades ago, he was out peddling his weapons throughout the world, ultimately got caught, got thrown in prison in The Hague or something like that for a few years, and then came back out and wanted to pick up where he had left off. Obviously, his name was blacklisted throughout the world. He couldn't really do business, couldn't open a bank account or anything like that. So he formed a Delaware LLC to be the front for his weapons trading operation. So the moral of the story is that Delaware doesn't really require a lot of personal information from you in order to form a legal entity. You can basically show up there and set up an LLC or a corporation, and they're not going to ask too many questions. The banks may ask more questions, but at least forming your initial legal entity is pretty straightforward in Delaware. And just a little bit of additional information on the Chancery Court. So Chancery Court hears about 4,000 cases a year. A lot of those cases are trust and estates cases. For whatever reason, they've ended up being the venue for a lot of those types of cases. But about 1,000 cases per year are of the type of business transactions that you would frequently think would end up in front of Delaware court. The types of things that fall into the categories I've listed below. The last category, public company M&A, the last statistic I saw was that of public company buyout mergers, something like 87% of those end up in court. It's basically shareholder litigation for these mergers has really become a very big nuisance, but it's also a very big business if you're on the other side of that. So a lot of those shareholder disputes end up in court in Delaware. I don't do a lot of public company M&A, so I don't really spend a lot of time keeping an eye on those cases, of which there's a lot of them, but these other types of cases I try to keep an eye on what's coming out of Delaware. So the first case I want to talk about is Winshall v. Viacom. It's a couple years old, from 2013, but I think it's got some interesting lessons to be learned, and it's an interesting case just in its own right. So this is the saga of Harmonix Music Systems. Harmonix developed Guitar Hero. I don't know if anybody remembers this game. Well, there used to be a video there that would show what Guitar Hero actually was, but it was a game where instead of getting a video game controller, you would get a fake guitar, and it would basically operate like a remote control. It would link up with what's going on the TV, and the idea was to play the guitar to the same rhythm and with some sort of accuracy to what was going on with the screen. It was very popular in about 2003, 2004, 2005. So at about that time, it really caught the interest of Viacom. Sumner Redstone was about 100 years old when he decided to make this purchase, decided that the time was right for him to pick up the video game that was a hot video game at the time. And so Viacom goes in and decides that they want to pick up all the stock of Harmonix Music Systems, which was at that time making boatloads of money off Guitar Hero. So the base purchase price of the transaction was $175 million. For all the, they also included a significant earn-out component. I don't know if all of you are familiar with what an earn-out is, but at its basic level, an earn-out is like an additional contingent purchase price opportunity that the sellers have the ability to earn additional purchase price depending on how the business they're selling fares post-closing. So in this case, what they did was the sellers got $175 million up front, and then they said, okay, if Harmonix does well in the next few years after we close, we might give you some additional purchase price. Earnouts are a little bit difficult to structure and frequently end up in disputes, and that was really the subject of this case as well. So in this case, the earnout was based on Harmonix's product gross profit in the 2 years following closing. The deal closed in 2006, and then what they did was they looked at, okay, Harmonix, what's your product gross profit in 2007, 2008? We're going to compare that to a pre-agreed target, and then we'll use that to calculate whether you're entitled to any earnout payment. Product gross profit, the definition here is important for the transaction, but it's defined as all product revenue, and then you take that revenue number and you subtract out certain variable costs. One of the variable costs was a big component of which is distribution fees. So Harmonix is the company that manufactures and develops Guitar Hero, but they aren't the ones that get it out on the shelves, and so they have to contract with a third party to to actually get that game out in front of the consumers, the distribution fees that Harmonix had to pay to those third parties were subtracted out of product gross profit for the purposes of determining the metric that was used for measuring the earnout. So as the acquisition was closing in 2006, Harmonix was in the process of developing Rock Band. Let's see if this video works. That's right. So Rock Band, does anybody remember this game? This was, the idea behind Rock Band was Guitar Hero, you got one guy with one guitar, Harmonix made a lot of money. Rock Band, the theory was, I guess, if you get 4 people, 4 instruments, hopefully make a lot more money. So instead of just a guitar, you had a bass, drums, and then I guess a microphone. It was all 4 people played together, and potentially it was it was supposed to be a very big successor to Guitar Hero. It came out in, I think, 2006, 2007, and it was a pretty big phenomenon at the time. So after closing, Rock Band comes out, and Harmonix needs to figure out how to get Rock Band out on the shelves. They contract with Electronic Arts to be the distributor of Rock Band, and they move forward at that time. So just an overview, Harmonix develop and manufacture Rock Band. They send it out to Electronic Arts, who takes it out, gets it on the shelves, and gets it in front of these guys, who then get to rock it out. So, all right, so back to looking at this earnout. As I mentioned, it's the achievement of product gross profit of Harmonix. Harmonix, this was a stock deal. So Viacom acquired all the stock of Harmonix, and you look at the product gross profit of the Harmonix entity in 2007 and 2008 versus that target that was agreed at the outset of the transaction. So the target was set before Rock Band hits the market. So remember, Rock Band hit the market after the transaction closed. The target was probably set when the transaction to buy Harmonix signed. So if the transaction closed at the end of 2006, there was probably a few months of regulatory approvals and other things before that they probably signed the purchase agreement sometimes in early 2006. So they would set this target about, hey, how are we going to measure product gross profit in early 2006? And they're trying to look forward and predict what's going to happen in that business in 2007 and 2008. And they didn't really know how well Rock Band was going to do once it hit the market when trying to set that target. So there's sort of a little shot of the timeline here about when the sale closed. Rock Band comes out a year later, and then you've got that 2-year earnout period. So Rock Band comes out in 2007. It was a huge success. I remember I was living in Chicago at the time. There were bars that would have parties for Rock Band. You could just go to the bar and go up on stage with 3 of your friends and play Rock Band. It was very popular.
You were really cool.
I was awesome. Yeah, very popular. My roommate had this game. I remember coming home and hearing like wailing of like awful Pearl Jam coming through the door. It was you could see these people playing this game. It was incredible. But in any event, a lot of people wanted to do it. Had a ton of sales, $1 billion of sales. So when you take those $1 billion of sales and you push them through the earnout formula, the Harmonix sellers had the potential to earn a huge earnout based on that $1 billion mark. So here's where sort of the wrinkle in this whole case comes in. So the earnout period was 2007 and 2008. In 2008, Viacom is making a ton of money from Rock Band. Electronic Arts is making a ton of money from Rock Band. For whatever reason, Viacom had the ability in 2008 to reopen those negotiations with Electronic Arts and rediscuss how their distribution fees were going to be calculated. And so what they did was, in 2008, they said, okay, Electronic Arts, you're making a ton of money, we still want to distribute through you, but we want you to take a little bit of a haircut on this. So in 2009 and going forward, yeah, we're going to ask you to take a little bit of a reduced distribution fee. We're not going to change anything for 2008, but in the future, 2009 going forward, you need to earn less distribution fees. That's important because of the way product gross profit was defined. Distribution fees are subtracted out of product gross profit for determining, for measuring the earnout. So 2008 ends. Everyone tallies up all the numbers. The sellers ended up making about $150 million in 2007 and somewhere around the same amount in 2008. So it's about $300 million in earnout. when you compare it to the $175 million they got earned up front, that's a pretty incredible outcome. I've never seen, on a percentage basis, an earn-out play out anywhere near that. So, yeah, the harmonic sellers made out pretty well. Notwithstanding, so here's the basically the timeline of all this, and it's important to the case itself. So the sale closes at the end of 2006, and you get into that 2-year earn-out period. First year, that earn-out rock band comes out. The second year, Harmonix, Viacom renegotiate the distribution fees of Electronic Arts, and then after the earn-out period ends, those new fees they become effective. So even though they made a ton of money, the sellers decide, oh, you know, we're sorry, Viacom, we're suing you as a result of this transaction. So the sellers assert a claim based on a breach of the implied covenant of good faith and fair dealing under the acquisition agreement. You know, implied covenant claims are pretty common. They're sort of a creature of state law. They're, as far as I know, in every state. They're interpreted differently in every state, but the general idea is that each contract that you enter into has at least some level of obligation to deal fairly with the counterparties to that contract. You know, every state interprets it differently, but that's sort of the general idea. What's a bit unusual in this case is what you frequently see when you see these claims pop up in a case. You see, okay, count one, breach of contract. We've got a specific term of the contract that's breached. We're going to assert our first claim on that. Count two, then they sort of throw in an implied covenant claim. Sort of as it's just a sort of a tossing claim. It's not something that they, you rarely see that the implied covenant claim is the sole claim that the one party is relying on. But in this case, there was not a claim of a breach of contract. The sellers were simply relying on an implied covenant claim for their theory of recovery. So the facts that they were basing this on, or at least their theory, was that, all right, in 2008, you had the ability to reopen those negotiations with Electronic Arts. You got them to accept lower fees in 2009 after. Really what you should have done, you had a ton of leverage at this time. You should have got them to accept lower fees in 2008 as well. Had they accepted lower fees, it would have increased the product gross profit and increased the potential that the sellers of the earn-out they could have earned in 2008. Well, they didn't do that, and so the sellers, suggested that Viacom should have used that leverage differently than they actually did. A couple of important facts that the court noted when they were looking at this claim. For one thing, the purchase agreement didn't contain any restrictions on the way that the buyer had to operate the business post-closing. A lot of times when you see earnouts, the sellers, they're cognizant of the fact that, okay, we're turning over this business to the buyer. The buyer's going to be able to change the way the business is run. We at least want to draw some boundaries around what the buyer can do so that they don't damage our earnout opportunity. Well, in this case, the sellers really didn't do that. There weren't specific protections baked into the purchase agreement that were negotiated at the time that the deal signed up. And secondly, the court found that it was important that Viacom, when they renegotiated in 2008, they didn't change. They had negotiated lower fees for 2009 and after, but it's not like they as a flip side of that, had Electronic Arts jack up the fees in 2008. They just sort of left the fees for 2008 as they were, and then just dealt with the new fees in 2009 and afterwards. So the case was initially before Chancery Court, and they dismissed the seller's claim. The sellers appealed it. Delaware Supreme Court, they upheld the Chancery Court's dismissal. The basic thing that they relied on, they're like, hey, sellers, you know what? You had the ability to negotiate some earnout protections when you had the chance. When this case was, when you signed this purchase agreement, you didn't do that. So we're not going to use this implied covenant of good faith and fair dealing to add additional obligations on the buyer that you didn't feel were worth adding when you had the chance to do so when the deal was signed. So we're not going to basically take a broad reading of this implied covenant like they're asking us to do. So the seller's claim gets tossed. What the court is nice enough to do is go on and give their thoughts about, well, what would have been a violation of the implied covenant in this case? Well, for one thing, if Viacom had, in fact, in 2008 said, all right, Electronic Arts, well, lower fees in 2009, but double those fees in 2008, okay, fine. Then that may be something that sort of reeks of bad faith and should be a violation of this implied covenant. Or if Viacom had been pushing revenue out of that earnout period with the intention of defeating the earnout, that would be something else that looks like it could have been a violation of the implied covenant. But Viacom didn't do these things, and so the court ends up saying that, all right, Viacom, you're off the hook on this one. So there's a few takeaway points here. If you do have a deal like this where you have an earnout protection, you do have to get some protections in the document. The court's really not going to do it for you. And earnout protections come in all sorts of shapes and sizes. I just pulled these from a sampling of deals, and the types of earnout protection that you put in there really depend on the business and the type of company and the type of metrics that you're using to track the earnout. But the idea is get something in there, get something to bind the buyer into behaving in a certain way, or addressing accounting issues in a certain way, or things like that. The court's not going to put these obligations on the buyer unless you do it on your own. Now the flip side of that is that buyers have a completely opposite approach. Like, hey, we bought this business, we want to be able to run it the way we choose. If you guys end up hitting your earnout because we've done a good job running the business, then so be it. We'll pay you extra money, but we're not going to have our hands tied with the way that we're going to operate this business that we just paid you a ton of money for. So buyers typically want to get something like this. On the flip side, this type of language into the purchase agreement that gives them the discretion to operate the business as they see fit. The second point is this implied covenant is out there. It's in all contracts. Now it's narrow though. The outcome in this case is not inconsistent with other Delaware cases on the implied covenant. There's a ton of case law in Delaware on the implied covenant, and the general idea is it's sort of a narrow gap filler. The courts will use it to try to understand something or try to construe a contract when something pops up that the parties didn't really think about at the time that they were drafting the contract. But Delaware doesn't take an expansive reading like the sellers were suggesting in this case, that the implied covenant should be used to impose a bunch of obligations on the contract parties that they could have contracted for, but just didn't really bother to when they were negotiating the contract in the first place. And then, if you're constructing an earnout, I realize there's a lot of business decisions that go into picking the metric that you're going to be using to calculate and track the earnout. What I always suggest, at least when we're on the sell side anyways, pick a metric that is near the top of the income statement. You have to realize that you're turning this business over to the buyer, and the buyer's going to have a fair amount of ability to manipulate the financials of the business going forward. And maybe you have negotiated in some sort of protections on their ability to do so, but without that, the buyer's going to have the discretion to use accounting and capital and the other aspects of the business in the way that's going to suit them. And ways that suit them may not really ultimately be consistent with achieving the highest earnout. Well, then you may be out of luck. So picking something near the top of the income statement, at least in my mind, gives the buyers a little less opportunity to manipulate those financials in their favor. So from a seller's perspective, I think a gross revenue number is really the best way in many cases to structure an earnout. There's less opportunity for the buyer to be moving revenue from period to period. And even the case we just saw suggested that if the buyer was actually moving revenue in and out of an earnout period, it's possibly something that would be reek of such bad faith that it would violate that implied covenant. Going a bit further down the income statement, a lot of times you see earnout structure based on EBITDA. Well, from a seller's perspective, yeah, okay, that's fine. But now you start getting a lot of expense and overhead items of the buyer into that calculation, that the buyer has a fair amount of discretion to allocate and to apply to adjust that earnout. And I was meeting with some folks and giving this presentation a couple weeks ago, and they were the buyer in a lot of deals that had earnouts, and they actually noted, like, yeah, this is, a lot of times we have these earnouts with sellers, and then they turn the business over to us, and all of a sudden, there's all these expense allocations that are being allocated to their business, which we're not doing it in bad faith. It's just how we run our business and account for a new division, and they've now suddenly got for example, percentage of legal fees allocated to their business that they might not have had before, or different types of benefit expense and things like that. And so there's ways that the buyer is going to do that are going to change the financials that could knock down the EBITDA number and impact your earnout. And then at the very bottom, sometimes you see an earnout structure based on net income. But from a seller's perspective, that's really tough. I mean, now you've got the buyer, all the buyer's interest and capital costs and other things like that go into that number, and there's a ton of ways that the buyer can really change those numbers if what they're trying to do, even as a sort of a symptom of what they're operating their business, is trying to keep that earnout to a minimum. So it's just subject to a fair amount of manipulation. In this case, they picked sort of a gross profit number. They had sort of a revenue number minus some of the cost of distribution. The gross profit, from a seller's perspective, pretty good as far as I see it. Not that subject to a lot of manipulation, but in this case, as we saw, it was one of those deduction items. It was the distribution fees that were the problem, that were the issue in this case. So, and then finally, this game is back out on the market. It's really just, you don't need to be seen playing this game. It's or at least be filmed playing it. So keep yourself off the internet if you're going to be playing Rock Band. And if you're doing so, there's no need to keep the Bud Light out of it as well. All right. Any questions on the Winchell case? All right. Well, next topic I'd like to discuss is the Delaware Rapid Arbitration Act. This is new in Delaware this year. I think this, as boring as arbitration statutes can be, I think this actually has the potential to be a useful tool, at least in some sorts of business transactions. So I don't want to get too in depth into the the text and the details, but I do want to give you a sort of a high-level overview of what the Delaware Rapid Arbitration Act is and where it might be useful. So as I mentioned, it's a new law. It was signed into law in Delaware in April of this year. Delaware tried to do something like this before. What they had done before was try to take sitting judges and get them used in confidential arbitration actions. Ultimately, that it was determined that was unconstitutional, and so that law had to be repealed. But they went back to the drawing board with the same basic concept, and they've come back with the Delaware Rapid Arbitration Act. It's not intended to replace traditional arbitration or traditional litigation, if that's what you're interested in, but it's intended to be a sort of another alternative that may be useful in certain cases. The main idea, though, is that this is supposed to be a speedy resolution, a very efficient way to resolve business disputes. I don't think this is going to be useful in all cases. For example, if you've got a full acquisition transaction where you're buying a whole company and you've got this complex indemnification structure, and you may, if you have an indemnity claim, you maybe need to be doing accounting due diligence, and due diligence is not the right word, but you need to take a closer look at the accounting, a closer look at discovery, and other specifics that go into that claim. I don't think this Delaware Rapid Arbitration Act is necessarily the right tool to resolve that sort of dispute. Where I think this might be useful is where parties are coming together and they may have a dispute, but they also have an ongoing business relationship. And so this may be a way to dispose of that dispute quickly and allow the parties to really get on with their life. One example, I guess, would be in an LLC operating agreement. So a lot of folks will, you say you pool your money together in a joint venture to pursue a common development of a product. I've seen on multiple cases where those investors get into a fight, and now you've got this fight going on for 2 or 3 years. All the investors are irritated with each other, and it's really just a huge detriment to the business. This could be a case where you've got this Delaware Rapid Arbitration Act. You might be able to wrap up that dispute quickly and efficiently and allow the parties to get on with their lives and hopefully minimize the damage to the business as a result. So the committee that put this together, they noted a couple things that they were trying to fix. For one thing, they said, traditional arbitration, okay, it's great, but it's really slow and really inefficient. There's this whole notion of gamesmanship within the existing arbitration, where even though you say, okay, we're going to go do an arbitration, well, then you may end up in court to decide whether the issue you're trying to decide is subject to arbitration or not. And there's a lot of ways that parties can really game the system to really slow it down and tie it up and really drag things out. And as part of that, now they notice that, yeah, there's a lot of arbitrators that make out very well in that system. And so we're attracting arbitrators that really just want to make a lot of money, and it's in their interest for these arbitration actions to get drawn out, and they're really not helping the cause to try to wrap these things up quickly. And then the flip side of that is, well, yeah, we're attracting arbitrators, but we're maybe not attracting the best folks. The people that may be best suited to resolve an arbitration action don't want to do it because they know they're going to get tied up for potentially a very long period of time. So maybe if we have a quicker, more efficient process, we're going to be able to get more qualified arbitrators that are going to be willing to sit and hear these disputes. So just some improvements that the committee saw in the Delaware Rapid Arbitration Act, and this is also sort of an overview of how this all works. But two parties that want to use the DRAA, they'll approach the Delaware court and say, okay, we need an arbitrator. We approach the court's then got 30 days to appoint an arbitrator that will be the decider for that proceeding. Once the arbitrator's in the action has accepted the appointment, they have full authority to decide every issue. They're not limited in the types of relief or anything like that. And they can craft discovery, they can craft the hearings that they're going to have. They can really set whatever rules or restrictions or timelines on the action that they feel is appropriate. Now, the one caveat to that is that the Act gives the parties the ability to set their own limits on it. So if your initial agreement that says, hey, we're going to use the DRAA, set certain limits on how you want that proceeding conducted, the arbitrator is supposed to abide by those limits and restrictions. Arbitrators, they have the full spectrum of relief available: equitable relief, injunction, specific performance, traditional money judgments. They really can issue whatever sort of relief that they feel is appropriate for the action. So here's sort of the most important piece of all this. So once that arbitrator is appointed, he's got 128 days to decide that case and issue his judgment on the matter. The stick in all this is that if he doesn't decide that case within that 120-day time period, then the fees starts to lose his fees, and they start to lose them very quickly. The schedule for reducing those fees is that if he's 31 days late in giving his judgment, he's already lost 75% of the fees for that. So it's a pretty tough remedy here. I think if they're over 60 days, all the fees are gone, and then they also have to write a report to the Delaware court about why they didn't give their judgment on time. And then you don't have to go back to the court for award. So once that your arbitrator gives its decision, that's really it. There's some limited appeal rights, but it's pretty limited, and the parties can waive those appeal rights, as we'll see later. So in many cases, once that arbitrator comes down with his decision, that's it. So there's, picking an arbitrator is always a big concern in the process. Who are we going to get? The DRA lets you do it in a number of ways. If you just want to drop someone's name in the agreement, okay, then they'll try to follow that. If you want to put a selection process in, each side picks one neutral party, they pick a third, something like that. Yeah, then you can put that in the agreement, and the court will try to abide by it. Otherwise, if the parties agree at the time of arbitration, they can obviously act outside of what the agreement specifies. If those all fail, and we really don't know who the arbitrator is supposed to be, then the Chancery Court has the discretion to select the arbitrator. Who can be an arbitrator? Pretty much anyone. You could have an ex-judge. I guess you can't have a sitting judge. We sort of learned that. You could have an attorney or an actor playing an attorney. You could have a titan of industry. There's really no limits on the types of people or the specific people that you can pick. Just because you necessarily can pick someone doesn't mean you necessarily should, but the Act gives you a lot of discretion to the parties to pick the folks that they may want to be settling their dispute. If it goes before the Chancery Court, they don't have quite the same discretion. They've got to try to pick the person who is named in the agreement. If it can't, then they'll try to pick someone from the industry involved, or ultimately from someone that's a member of the Delaware Bar. A few other points. You can only use the DRAA for business disputes. It can't be used with consumer transactions. No monetary thresholds. If you have a very tiny case, you can still use the DRAA to resolve it. There's none of the diversity threshold that you'll sometimes find, though you will find again in the federal court. That doesn't apply here. So you have to have a written agreement to arbitrate. There's two ways I think this will play out. If parties are getting to, they already have a dispute going on, and they decide, hey, we want to settle this by the DRAA. Okay, then they can sign a agreement to arbitrate at that point. What I think will be more common, assuming that this act gains traction, is that parties can put it in their initial contract. You put it in your operating agreement, or you put it in your distribution agreement that says, if we have a dispute, we're going to go settle this using the DRAA. Here's how we're going to pick our arbitrator. These are some of the rules that we want to use in our process, and then hopefully we can wrap up any dispute within 120 days and get out with our lives. The agreement has to be governed by Delaware law. That's just the basic requirement under the statute. You have to mention the DRAA by name, and then one of the parties has to be a Delaware entity. This is a bit of a problem if you're outside the state of Delaware, but you do like the way that this act is set up. What the guidance suggests you can do is that one party could actually just form a Delaware entity simply for purposes of opting into the DRAA. So it doesn't have to be a real quote-unquote substantive entity. It could just be a shell entity, but that's one way of being able to use this. Other than that, the agreement can put whatever sort of restrictions or conditions or timelines or other sorts of conditions on the arbitration process that they want, and then the arbitrator is really supposed to try to abide by that. Mr. Heineman.
How would you structure having two non-Delaware entities, set up a shell Delaware entity to arbitrate? Would you then have to have some sort of agreement, like a sale of your arbitration rights to that entity? Or how would that even do that?
So the question from Attorney Heineman was, how would you structure it so if two non-Delaware entities wanted to use the DRAA, how would you go about forming a new entity to use that? I think the easiest way would be that one of the parties could form a new sub and have that sub just sign on to the agreement, or not even. I think they just can sign on for. If they have no assets, there's no real exposure for them to that sub joining it. You just have now someone that's a Delaware entity, and you don't have to have one on each side. You just have one Delaware entity on one side.
So that's sort of damaged.
No, they just have to be a party to the contract.
Oh, okay.
So
then anybody can jump in.
Yeah.
Any party to the contract.
Yeah, I think so. That's a good question, actually. I don't know how that would play out if you had a subset of the folks. I'd have to look into that. Let me take a look at the statute, and I'll get back to you. All right. Appeals. Parties can waive their right to appeal if they want. That means the decision of the initial arbitrator is final. You could also specify, all right, if one person doesn't like the initial decision, then we've got this appellate arbitrator, and that's where you can get Miley Cyrus in as your appellate arbitrator or whomever else you want. Or if you want to have a selection process, anything like that. If there's no, if the agreement doesn't say anything about appeals and doesn't waive them, then the parties have 15 days. They can appeal it to the Delaware Supreme Court. The statute says that the Delaware Supreme Court is supposed to review the decision consistent with the Federal Arbitration Act, which is, I don't believe is any sort of re-examining the facts from start to finish. I think they're looking at it from a sort of an abuse of discretion type review, but I'm not entirely sure what the Delaware Supreme Court review would be in that case. A few other things, a lot of folks really like arbitration because it's confidential. So the DRAA, it'll be confidential proceedings as well. However, if you end up getting to the Delaware Supreme Court and that appeal is taken up by Delaware Supreme Court, then the confidentiality will be waived at that point. You can have those proceeding anywhere in the world. Proceedings don't have to happen in Delaware. They don't have to happen in the United States. And then you can't use these in charters or bylaws. The idea is that the signatures of all the parties, I see this may answer your question, it might be all the parties to the dispute have to be signed in that contract. So maybe you would have to have your Delaware entity be a party to that contract and a party to the dispute. So that's an interesting thought. But in any event, you can't use these in charters or bylaws because not all the shareholders in corporations are typically signing those. Any questions on the DRAA? All right, we got a little more time here. I'll try to click through this case relatively quickly. So Great Hill v. SIG Growth. This case deals with how attorney-client privilege is handled in M&A transactions. It's a bit of a hot issue among M&A commentators in the past few years. So just a brief overview, attorney-client privilege protects communications between the attorney and the client. Communications have to be for the purpose of seeking legal advice, but if they fall into that bucket, then the communication should be protected from discovery in an action. The holder of the privilege is typically the client, and that's sort of an important considerant in the case that we're going to see. And it can be lost, and it's very commonly, parties will copy accountants or bankers or other parties on emails, and then later on they say, hey, wasn't that privileged? No, you copied someone on an email, it shouldn't have been there, or alternatively, you copied the other side on that email, and so the privilege is lost in those cases. Privilege is lost inadvertently quite frequently, and something that a lot of people need to be more aware of and aren't. So this is an ongoing case, or last I heard it was ongoing. This is just a memorandum opinion in this ongoing in this case. Came down in November of 2014. So the dispute involved a company called Plymouth. Plymouth was an e-commerce solution. And what Plymouth did was they would go out to find brick and mortar retailers that didn't really have a very developed online presence. And they say, okay, retailer, what we'll do is we'll form this online presence for you, this online marketplace, and we'll run it for you, and we'll try to attract new online customers that you wouldn't have normally missed out on. They grew a lot. I think they formed in 2001, and they grew a lot in the subsequent years. And now, at last glance, their email or their website said they were in 180 countries, and they were doing a bunch of different payment types. So they're now known as Blue Snap, and they've evolved a bit since this. So Plymouth was formed in 2001, as I mentioned. They're a private company. For many years, they were owned by just the founders, the initial guys that decided that this is the idea that they wanted to pursue. In 2008, they went and had a venture capital round with SIG Growth. SIG Growth is a venture capital firm. I think they invested something around $18 million. The founders used that to go and attract a professional management team. And let's see, the management team did a great job of really developing the company. So they had about 3 years there, and they grew the company leaps and bounds. By 2010, the founders had been in for about 9 years. SIG Growth had been in for a number of years. Founders say, we want out. SIG Growth is like, okay, fine, let's get out of this thing. So they engaged Raymond James, the investment bank, to go pursue a sale of the company, and they engaged Perkins Coie to serve as legal counsel. 2011, Great Hill is a private equity firm. I believe they're based out of Boston. They get exclusivity. They agree to buy Plymouth for $115 million. The transaction was structured as a merger of Plymouth with the buyer, a reverse merger. In essence, the structure, the buying company on the left would form a new acquisition subsidiary, and then the target company on the right, which was Plymouth, would be merged with the acquisition subsidiary. This is a reverse merger, so the target company would be the entity surviving on the bottom of the acquiring company as a new subsidiary going forward. So the merger closed in September 2011. So about a year later, Great Hill ultimately sued. So at issue in the suit were the payment processor relationships of Plymouth. So Plymouth sat between, basically sat between retailers that made these products and then consumers that were buying these products online. Well, an important third prong of the triangle was the folks that moved the money. And so PayPal, as I'm sure you all know, in online transactions is at the forefront of interacting between consumers and the banks, and they're the leader in that niche of moving cash from online consumers to online retailers. So Plymouth had relationships with PayPal and some of the other folks that operated those types of businesses. Before this company sold, the owners of Plymouth were quoted as saying, these relationships with PayPal are the most important relationships to our business. Well, in the weeks and months leading up to the sale, the relationships with PayPal and Payment Tech and the others started to unravel. So PayPal interacts with the banks very closely, and so they have to follow a lot of the standards that the banks have with regards to moving money and money laundering concerns and things like that. And so they pass on all those standards and requirements to the parties that they contract with, like Plymouth. Plymouth apparently played pretty fast and loose with a lot of PayPal standards. And in the weeks and months leading up to this sale transaction, there were lots of emails from PayPal that say, hey, Plymouth, you violated this standard, and we got a nasty email from our bank. Hey, Plymouth, you broke this rule of MasterCard. We just got hit with a $200,000 fine. Hey, Plymouth, you got to get your act together. Well, Plymouth never really did. And so even right before the sale to Great Hill, I think Payment Tech terminated their processor relationship with Plymouth. And then either right after the sale with Great Hill or right before closing when regulatory approvals were getting obtained, PayPal ended up terminating their processor agreement with Plymouth as well. So the problem in this case is that none of these issues were ever disclosed to Great Hill. The Great Hill met with management leading up to the sale, and management never mentioned that the processor relationships were falling apart. They weren't listed on the disclosure schedules to the acquisition agreement. Nothing was really brought to the attention of the buyer that these are important contractual relationships are falling apart. Most troublingly is that ultimately it was found that there were a lot of emails in that period leading up to the sale between the management at Plymouth and Perkins Coie, the legal counsel, basically to the effect of, hey, Perkins Coie, how can we cover this up so that the buyer doesn't learn about the fact that these processor relationships are falling apart? So ultimately that all sort of stinks of fraud. Fraud is important in these types of transactions for two reasons, really. These purchase agreements are all subject to indemnity provisions, which allow the buyer to recoup a portion of the purchase price from the seller if problems with the business arise post-closing. Those indemnities are always subject to negotiated limits and caps and baskets and carve-outs. Well, it's frequently the case that one of the exceptions to those exceptions and those limits is that if the buyer can show that there was fraud on the part of the seller, that they're entitled to get out of those indemnity caps and other limitations. Secondly, those purchase agreements typically say that the indemnity provisions are the only way that the buyer can recover from the seller's post-closing, and the buyer waives any other rights to pursue other causes of action. It's called an exclusive remedy provision. Well, one of the carve-outs from that is that if the buyer can show that there was fraud, then that exclusive remedy provision goes away, and then the buyer is free to pursue whatever cause of action it wants, including rescission, which is a remedy for fraud under common law. And that's really what Great Hill ultimately ended up doing in this case. So Great Hill takes over the company. They have the servers, so they take over, they start running the company, they realize that the relationships with PayPal are now gone, and then they start digging through all the emails that they got, and they start finding all these emails between the sellers, officers, and directors and Perkins Coie. They go trotting into court, waving emails around and say, hey, fraud here. We want to rescind this deal. Well, the seller will say, wait, those emails were attorney and the client. They're attorney-client privilege. You can't use those to assert your fraud claim. So what's the court to do? So they end up in court. And Chancellor Strine, he's sort of one of the most well-known judges in Delaware. I think he's the chief judge of the Delaware Supreme Court now. And he sort of looks at it from three angles. And from a corporate law perspective, he says, okay, you guys structured this as a merger. So Plymouth, the legal entity Plymouth, merged with the merger sub and became a subsidiary of the buyer. Well, the statute says that when you've got a merger, all the rights of that subsidiary, they stay with the company following the merger and become the rights of the surviving corporation in that merger. So sort of looks like from the statute that the rights that Plymouth had pre-closing were the rights of that subsidiary post-closing. So he says, okay, this privilege that Plymouth had, the privilege between Plymouth and Perkins Coie, it went with Plymouth in the deal, and now it's basically owned by Great Hill as the buyer. And so he points to that statute and says, privilege is Plymouth's corporate asset, and it went along with it. He also notes a couple practical concerns. He's like, in the merger agreement, the parties could have structured around this. It's common in these types of transactions, becoming increasingly common, to see provisions in these documents that say, okay, even though this privilege would be a corporate asset and go to the buyer in the deal, we're going to sort of change how that is, and we're going to all acknowledge that the privilege is an asset of the sellers, and it's not going to be for the buyer to assert that privilege post-closing. In this deal, they didn't do that. There wasn't that sort of provision in the merger agreement, and that was one of the factors that the court points to in this case. And then, the court also noted that SIG, the seller, they didn't really do anything to show that they valued these emails or thought that they were privileged until they actually needed to once they were in court. They didn't take any actions leading up to closing to segregate or protect the emails, nor did they take any action immediately after closing to try to retain control over the emails or show that they thought that they were protected. So the court says, okay, Great Hill, yeah, you've got the emails. They're your asset. You can use those emails to assert your fraud claim against the sellers. So a few takeaway points here. Let's first of all, from the outset, think about who's the client. So the privilege is an asset of the client, as this case shows. Well, it's important to think about really who is the client. The court sort of glossed over this issue in this case, I thought. They didn't really think about, well, is Plymouth the client, or are the selling shareholders the client? Like, who really is the client here? What I suspect happened is that the court sort of acknowledged that there's a ton of overlap, at least in this deal. You've got the founders, who would be the management, they would be the officers, they would be the directors. They had a significant equity stake. You'd have SIG, the venture capital firm, was the significant shareholder, but they were also had board appointees. There was just all this sort of mixing up of all these different roles that the court finally just said, Plymouth was the client, and they're the ones who owned the privilege. That's what I suspect. There wasn't any discussion on this issue, but it's important to think about who is the client and who will own that privilege going forward. If you got a merger or stock purchase agreement, you can include the provision that the court suggested. State, who you think those emails are the property of, and who's going to be able to assert the privilege over those emails post-closing. Asset purchase agreements, you don't typically see this, but I think the same logic applies that you would see in a stock purchase agreement, and that sort of includes including these in asset purchase transactions. But think about whether the emails and the privilege should be an excluded asset or a purchased asset, depending on the side. So on the sell side, definitely started including the attorney-client privilege and the emails as excluded assets. And from a practical perspective, think about where that server is ending up. And just because something is noted as privileged doesn't necessarily mean that the buyer can't look at it and particularly glean helpful information from it. And so there's something to be said for thinking about what's on your servers before you turn it over to the buyer as well. And before closing, show that you value these communications. From our sellers that use corporate email addresses, we always suggest, hey, if you're selling stockholders, get a Gmail address. Show that you think those communications are not a corporate asset and that you intend that those emails should be protected and subject to privilege. So as long as we can get a Gmail address. And then this is really just, don't be dumb, but think about who you put on your emails. If you're copying accountants and bankers and other folks, you're probably going to end up blowing that privilege. So be cognizant of who you're sending these communications to. And then a lot of times, just pick up the phone. Some things aren't meant to be put in text. If you think about what the Plymouth sellers, if they would have just called Perkins Coie rather than putting some of the stuff in writing, it may have helped their case at the end of the day here. And finally, after the closing, take actions to show that you think that these emails are protected and should be segregated. The sellers in this case didn't do this, but avoid any sort of argument that you've waived your right to assert that privilege. Any questions? All right, well, thanks. Oh, we have a couple questions from the webinar. From the folks following along at home, glad you're all paying such good attention. These are great questions. What is your impression of Delaware judicial decisions as compared to decisions from other states? That's a great question. Well, my impression is that when you read the decisions of judges in Delaware courts, at least in these types of transactions, they sort of get it. I mean, they see so many of these types of deals and so many of these types of transactions that they really do have the expertise that they're sort of supposed to have. So when you read through these cases and then you get to the holding and you get to the outcome, more often than not, I'm like, yeah, that outcome kind of makes sense. Not so much, I guess, when reading some of the few cases in corporate transactions that pop up in other states. A lot of times you read those and the logic is maybe a little bit lacking. So I think Delaware is, I think the judges there typically do a pretty good job. Now the flip side of that is I've heard that if you're pursuing a litigation action in a Delaware court, you need Delaware local counsel. And from what I've heard is that there's also a lot of, it's sort of a small club in Delaware. There's a little bit of everyone kind of knows each other and you don't really know what impact that's having on the decisions. That's just sort of what I've heard through the grapevine a little bit. I don't know if there's any fact to that whatsoever. And I think that's about it. And I think we're at the end of our time here. So thanks everyone for coming.